the way and shows the way. John Maxwell. Welcome to the Guyana Dialogue. I'm your hostess, Shamiza Ali. Tonight, we will discuss the status of constitutional change and electoral reform. The Guyana Dialogue is being sponsored by a coordinating council of Guyanese based in the US, UK, Canada, the Caribbean, and Guyana. Funding support is by well known philanthropist Dave Narine from Dave West Indian Imports. Joining me tonight are Dr. Tara, Dr. Vishnu, and Mr. Shrad Kublal. He is the Attorney General and Minister of Legal Affairs. He served in that capacity in the last PPC government under the President Donald Ramotar. He also heads the Parliamentary Constitutional Reform Commission. He serves as the Secretary to the Defense Board. He has distinguished himself in fighting to preserve democracy following the 2020 elections fiasco. Please welcome Mr. Anil Nandlall. Welcome. How are you?
I'm fine, thank you. And I must thank you for affording me the opportunity to appear on your program. And I wish to say good evening to your distinguished panelists and also, of course, all your viewers and listeners across the diaspora, Guyana, and the Caribbean.
Pleasure having you here this evening, Dr. Tara.
Welcome, Mr. Attorney General. We are very pleased to have you. With me to the left is Dr. Vishnu Bisram, who will do most of the questioning tonight or seeking clarification. And then Shrad Kublal, whom you would have met on one of your visits to New York. He's an urban planner by profession. He's also teaching in the secondary school in New York City for quite a while. But before I pass you to Vish, I just want to ask you a question or rather clarification. The PNC during this week said that a petition can bring the election fiasco to a finality. In other words, they don't have too much of faith in the COI that has been just established by the president. So can you please throw some light on that, on what you think of that position?
It's sometimes very difficult to comprehend what the PNC or APNU AFC say. Sometimes it does not make sense. So if you are quoting them correctly, that a petition will bring the issue to an end. Well, they have filed 2 petitions soon after the elections, both of which were dismissed in the High Court, and both are in the appellate system of the judiciary. So what other petition are they speaking about? The fact that they lost the petition, in their minds, obviously, it did not bring the requisite resolution that they filed it to achieve, hence the reason why it is now in the appellate process. So I don't understand what petition they're speaking about.
Mm-hmm. And I know many people were asking what happened to the PP petition in 2015. That was never heard. And if there is so much faith in petition, that should have been heard to clarify any kind of misconceptions or irregularities in the election. That didn't happen. 2015 election at PP file.
And perhaps I should speak a little about that. Okay. The elections petition by their very nature and by the rules and law governing elections petition is that they must be determined with alacrity, simply because they deal with the resolution of who shall sit in the parliament and who shall form the government of any given country. So because the resolution of those petitions are so integral to law and order and to society itself. The law has created a number of rules and checks and balances to ensure that these petitions, once filed, are heard with every convenient speed. In fact, it is stated expressly in the law that once a petition is filed and the hearing begins, it must be heard on a day-to-day basis. It is the only species of litigation in the world where the law itself says that the case must be heard on a day-to-day basis. You would recall that petitions were filed against the PPP government in 1997, for example, and it went to trial and it was heard and determined. And that term of the PPP government was abbreviated and fresh elections were called. The PPP was in government. That petition filed by Esther Pereira was the first time in the history of Guyana that the elections petition was heard on its merits and went to trial against the government of the day, and the government of the day got a ruling adverse to it from a judiciary. I say that to you so that you appreciate the level of democracy that prevails in a country or prevails in Guyana when the PPP is in government. And that petition itself presents indisputable proof that there is and there was no interference by the executive with the judiciary or no form of intimidation whatsoever. The judge who heard and determined that petition against the PPP government subsequently got a job with the PPP government and worked in successive PPP government until I was Attorney General and she was working under me from 2011 to 2014. And then she got another job under the PPP government as the police legal advisor. And then she was nominated by the PPP, or her name was submitted by the PPP to President Granger for her appointment as chairperson of the Elections Commission. I say that to you and so that your viewers understand the type of political and democratic atmosphere that permeates a society when the PPP is in government. Now, fast forward to the direct question you asked. What was the fate of the petition filed by the PPP when we were in the opposition? Now, I am not making any allegation or casting any aspersion. All I am saying is that that petition was filed and for 5 years it was not heard and determined. That is a fact. I leave the inference to be drawn by your viewers and by yourselves. So there it is that you have the difference in the democratic credentials of the society when different parties are holding the seat of executive governance in Guyana.
Thank you very much, sir. I'll now put you on to Vish, who's going to follow up with constitutional change.
Yeah, before I get to constitutional change, and I think this would lay the background for constitutional change and electoral reform. You're speaking about democracy and the election petition. I was wondering if you could just touch on Tuesday's appointment of this commission of inquiry into the attempted fraud of 2020, and that will give us some background as to the need for constitutional reform.
Tuesday, the president named the persons who would constitute a commission of inquiry to be established. They are not appointed as yet. They were simply named. That inquiry, as we promised even before we got into government, in particular during that 5 months period, followed by the president himself in his inaugural address at the National Cultural Center, promised that we will have an inquiry of an international type to interrogate and inquire into the irregularities that affected the March the 2nd regional and general elections, more particularly the events that ensued elections day. Because as you are aware, elections day's activities were quite peaceful, and all the international observer teams who observed those elections, including United Nations, Carter Center, CARICOM, Commonwealth, Organization of American States, and a whole host of locally accredited organizations such as the Guyana Bar Association, the Private Sector Commission, religious bodies, and other important civic society organizations, all certified election day's activities to be free, fair, transparent, orderly, and in accordance with regularity and law. The mayhem and the atrocities began about 2 days after the elections, when the votes for Region 4 were to be tabulated by the returning officer, Mingo. That marked the beginning of perhaps the most bizarre and outrageous series of events witnessed in recent years in this hemisphere concerning an elections.
Okay, so you're done. All right. So in 2015, the opposition, the then opposition, which became the government, APNU, AFC, PNC, had committed to constitutional reform. But over the 5 years that they were there was no, as far as I'm aware, no gathering of any committee to discuss constitutional reform. The PPP had made similar commitments. So I wonder if you could just give us a status position of constitutional reform.
Constitutional reform is a very hot subject in Guyana. And it's a good thing that we are discussing constitutional reform. It has quite a history. And if I may go back to do a more comprehensive examination of the concept of constitutional reform so that I can bring you from where we are, to where we are, sorry. So your panel would be well aware of the machinations and the illegalities that birthed the 1980 Constitution. You are well aware of the historical wrongs committed in relation to a referendum that produced that election, that constitution. You also may be aware of the authoritarian structure of the Constitution and the heavy concentration of power that was resided in the executive president and the executive general. The PPP was opposed in the referendum process, and when that constitution was imposed with a rigged referendum, Dr. Jagan and the PPP registered their protest against that constitution and maintained that position until 1992, promising constitutional reform as soon as they get into government or shortly thereafter. One of the first things that Dr. Jagan did when he got into government after 1992 was to establish a committee to examine the idea of constitutional reform. I recall it was headed by the head of the Catholic Church, Bishop George, I believe. Before much could have been achieved, the 1997 elections, Dr. Jagan died, then the 97 elections came. And after the 92 elections, everybody was busy with building back a bankrupt country. You had Desmond Hoyt vowing to make the country ungovernable. The 97 elections came. You had massive violence, social upheaval, Hoyt threatening to make the government make the country ungovernable, and a whole host of things that made government very, very difficult and make management of the society extremely complex. Then you had the CARICOM intervention and the Harmanston Accord. It is in the Harmanston Accord that the political parties went to the table and they agreed to wide-ranging constitutional reforms. Those were effected by a broad-based commission appointed by the People's Progressive Party, where the opposition and the government shared joint membership along with a broad cross-section of civil society. That commission was given greater functional autonomy and independence to go to the people, to take submissions from them, take recommendations from them, and make recommendations, prepare a report and make recommendations for constitutional reform. That task was completed. The PPP all the time was the government. Over 200 changes were made to the Burnham Constitution. The thrust of those constitutional amendments was reduction of powers of the president, reduction of powers of the executive, increase functional powers of the opposition, and in particular, enlarging the powers of parliament so that the parliament can play a greater role in appointment process and in many, many things like oversighting governmental conduct and oversighting government activities, etc. Parliament being that multi-political partisan assembly. So when they say Parliament has the power, is the opposition and the government together exercising that power. So there was great devolution of power from the executive to the parliament and by extension, the opposition, as well as great devolution of power to local government organs. The electoral system itself was significantly altered in terms of the allocation of seats, where you had 40 seats under that amended constitution going to geographic constituencies and 25 getting being elected through top-up votes. So you had a radically new structure in terms of how political representation was to be done. All of those changes have culminated into the constitution that we have. 2 months ago, the president of the Caribbean Court of Justice was present in Guyana, and he was invited to speak at a bar association dinner. And in his speech, he hailed the Guyana Constitution as perhaps the most progressive constitution in the entire English-speaking Caribbean. a statement that I have made over 20 years ago. We have in our Constitution a series of provisions which empower the opposition in decision-making process or decision-making processes in relation to a host of fundamental positions. So the Chancellor and the Chief Justice, who hitherto were to be appointed by the President after consultation with the leader of the opposition, are now only appointable by the President with the agreement of the opposition. That's one. Two, the service commissions, which the constitutional theorists will tell you constitute a formidable regime of checks and balances against executive authority. The police complaints of the Police Service Commission, the Public Service Commission, the Judicial Service Commission. Judicial Service Commission deals with appointment of judges and recommendations as to who will be appointed. That, for example, was changed to say that when the Judicial Service Commission makes an appointment, makes a recommendation, and the President fails to act, he can send it back one time. And if the Judicial Service Commission reconsiders the matter and sends back that appointment, that recommendation to the President, he's compelled to appoint that judge. That was never there. That is not in any other constitution in the Caribbean. I just give you one example. But I'm dealing with the appointment process to these commissions. Each of these commissions, persons are appointed through a parliamentary process where Parliament does the selection in a committee within the Parliament called the Appointments Committee, after consulting important stakeholder organizations in the country. In fact, the Police Service Commission is so bad, and this commission deals with the promotion and discipline of police officers from the rank of inspector going up just below the commissioner. That commission, the constitution is so structured that every single member of that commission comes from the National Assembly. And the President is only required to consult with the leader of the opposition in respect of the appointment of a chairman of that commission coming from the names or the nominees from the National Assembly. The role of the President is completely miniaturized. There is no constitution in the Caribbean where such limitations are placed on presidential power or executive power in relation to service commissions. We also have a series of commissions that do not exist in any other region, any other country. We have a Gender Equality Commission. We have an Ethnic Relations Commission. We have a Rights of the Child's Commission. We have an Indigenous Peoples Commission. These are important bodies that are comprised of non-politicians. They are appointed again through a process done by the Parliament involving the opposition. And these are powerful bodies within our constitutional structure that members of the public can go and lodge complaints of any type within those commissions require investigations. Then we have a series of standing committees created by the Constitution. We have a Natural Resource Committee. We have the Public Accounts Committee. We have an Economic and Service Committee. We have a Foreign Relations Committee. We have a Standing Committee on Constitutional Reform. Again, there is bipartisan representation in all these committees, and none of them can be chaired by a minister. Backbenchers of the government and opposition constitute these committees, and the chair is rotated based upon agreements within the committee. And these are committees that can summon ministers, summon public officers, summon public servants to these committees and interrogate them on any matter involving public funds that fall within their sphere of activities. You have the Public Accounts Committee, which is the committee that investigates all public spending, and that is all year round chaired by the opposition. An opposition MP chairs that, and it interrogates government expenditure. The parliament itself is managed by a committee called the Parliamentary Management Committee, which is equally constituted, equal number of government and opposition. And it is this committee that manages the affairs of the parliament. I have just touched the tip of the iceberg in showing to you how powers have devolved from the executive into non-executive organs within our constitutional structure. And almost all the examples that I've cited to you, we are different from the Caribbean. The Caribbean constitutions and the rest of the Commonwealth still maintains the pure Westminster structure handed down by Great Britain when these territories obtained their independence 50, 60, and 70 years ago. We have radically changed our constitutional structure since. So, and that is where I want to bring you to where we are with our constitution, to now address the question of constitutional reform. I began this discourse by saying to you that constitutional reform is a very hot topic. I am going to move a little to say that it's not only a hot topic, but it's a sexy topic in Guyana. Has great political sex appeal. So every person who can get his political way and can get into government by ballots, they turn to the Constitution and they fault the Constitution for them being out of power, and they identify that Constitution as the panacea to solve their political disastrous positions. So we promise constitutional reform, and we have effected the widest array of constitutional reform since independence in the most democratic way. That is the credential of the PPP. Every time the APNU, AFC, PNC, every time they lose an election, they want constitutional reform. Every time they're in the opposition, they want constitutional reform. When they were in the government for 5 years, not a single real step taken in the direction of constitutional reform, although it was one of the main platform promises. I say that to you to say that they are not interested, and there's a whole body of persons in this country who are not interested in constitutional reform for the benefit and betterment of the country. They see constitutional reform as a vehicle to get them into government by a mechanism other than popular vote. So you will hear now the Henry Jeffrey and my neighbor from Buxton, what's his name? Arizona guy.
Hines.
David Hines.
David Hines.
You will hear Professor David Hines and Dr. Henry Jeffrey will use great intellectual garb as they mask this call for constitutional reform. It's not constitutional reform they want. They want to share, they want a grab of executive power, but they're using the disguise of constitutional reform because it has sex appeal among the masses. So I want to put frontally out there that there is a large body of persons who are hiding under the mask of constitutional reform, but want to use it as an avenue to get into executive power when they know that they can't win an elections. So APNU, AFC now have obviously realized that they will be in the pasture for a long, long time. Constitutional reform can provide them with an abbreviated journey into government if they are able to manipulate and they are able to interfere with the constitution in sufficient way to make it weaker, to undermine the democratic credentials. And that is what I'm saying when we get to speak about the electoral reforms. They are not interested in electoral reform. They are happy if we can even break the system down greater to enhance their ability to thief the elections, as they attempted to do for 5 long, agonizing months. So when you hear these people speak, you must be able to decipher their true intent and unmask them when the opportunity presents itself. And that's what I want to do tonight. We in the PPP, however, we have made a promise. I have great difficulty in advising a president, for example, in relation to appointments where the executive must play a part because we are answerable to the people in government. But our ability to select, have a free reign in selection, has been severely circumscribed by constitutional limitations. I have a problem with that. No other executive in the region or in the Commonwealth is so burdened. But we are expected to deliver like everyone else. But our constitution imposes limitations on us and creates strictures upon us that does not exist or do not exist anywhere else. There are other things that we would like to change in the constitution too, progressive things as well. It's not only about, but I mean, as the conversation unfolds, I guess I'll get to that.
Yeah. You said that the PP has made substantial constitutional changes, about 200. And we know that what is the link? The opposite side of that is that what's the point in having constitutional change and people are not observing them, as happened with the PNC, right? Granger, the Carter Price formula to choose the chairman of GECOM, they torpedo that, and there are other constitutional provisions that they torpedoes as well. So the question is, any kind of constitutional reform should have a compliance, some punitive clause. Can you say whether the existing constitution has any penalty clause, violations or infractions of the constitution?
Dr. Karasing, if you go back in the archives just a few years ago, while we were in the opposition, many times I have made the point that constitutional compliance must always take precedence over constitutional reform. What are you reforming when you're not even obeying what you have? For 25 years, beginning with Desmond Hoyt, a senior counsel, followed by Robert Corbyn, another lawyer. For 25 years, no one had any problem in interpreting the article that speaks to the appointment of a chairman of GECOM. Nobody ever had a problem with it. None. Not Cherry Jagan, not Desmond Hoyt, not Janet Jagan, not Samuel Hines, not Bharat Jagdev, not Robert Corbyn. Then David Granger came along. A soldier. Corbyn is a lawyer. Hoyt is a lawyer. This guy is a soldier. And he seemed to know no more law than Hoyt and Corbyn combined. And he had this entire nation upside down in misreading and misconstruing clear, simple English language that we were reading and interpreting 25 years now. Simply because he wanted to pervert the Constitution and choose a person of his own liking to be the chairman of GECOM so that he can complete the task of stealing those elections. So I agree with you fully. Now, this, I don't know if your camera can, this is this Guyana Constitution. You see the size of it? It has 375 pages. The Indian Constitution is about 1/4 of this size. 1/4 of this size. This Constitution that I have in my hand is 375 pages. It governs 750,000 people. India has 1.3 billion people. There are more people in one part of some village in India more than the entire country. And the Indian Constitution is 1/4 of this size. The American Constitution is about 1/4 of this size. And it governs 350 million people. And we have a constitution of this magnitude for 750,000 people. We can't count 500,000 votes in 6 months. The whole world saw that we couldn't count 500,000 votes or less in 6 months. I am not making these things up. I just show you the size of the Constitution. It's a pity I don't have the Indian Constitution with me and the American one. I'll show it to the screen so the viewers can see what I'm speaking about. But you hear every day constitutional reform when they are out of government. When they were in government for 5 years, Nagamutu was given 2 responsibilities. 1, to look over Chronicle and NCN, and 2, constitutional reform. 2 things had to ask him to do for 5 years.
I want to follow up with another question. My understanding of the Constitution is that certain provisions, changes in the Constitution, cannot be made by 2/3 majority in Parliament. You have to go back and do it by a plebiscite or a referendum. Can you please elaborate or comment on that? My view is if you have a Constitution and you have important provisions, that should really go via referendum. The people should have a say rather than a parliamentary select committee making this decision. So if you can comment on that, please.
All right. You have asked me a very complex question, and it requires a breakdown. So let me start. So we have what is called levels of entrenchment in our Constitution. Entrenchment simply means is the device that secures the particular provision. And by that entrenchment mechanism, some constitutional provisions can be changed by a simple majority, and those are very few. And as you get more important, the level of entrenchment increases. Then the second set or more important set of provisions can only be changed by 2/3 majority. And then the most fundamental set of provisions can only be changed by referendum. Right? And that is in the Constitution itself. They are listed in that way, in a particular provision. Article 164, called the entrenchment provision of the Constitution. So the undertaking that we will embark, that we promise to embark upon, of constitutional reform will not be one that will be by referendum. We promise to change because, referendum is very, very, is the core of the Constitution. I don't think anybody advocating the change, like core things of the Constitution. We want the attention will be directed to changing those provisions that are secured by a 2/3 majority. Because And that is when you need bipartisan support. And that's the point I keep making, that one political party can't achieve constitutional reform of any substantive and substantial nature. You have to have bipartisan cooperation. But going to the people, recall, is not a committee that's sitting in a room to effect these changes. These changes are going to be effected by an engagement with the public. And that is why the Constitutional Reform Commission, when it is established, will have a wide range of powers to travel the length and breadth of the country to hold public consultations. So while it is not a full-fledged referendum, this exercise will receive, hopefully will receive, the mandate of the widest cross-section of people in the country. But Tara, what you have to understand also, Dr. Singh, sorry, I call you Tara. What you have to understand also is how much can you change in a constitution unless you want to create a radically different legal system. We have a legal system, and that's what people don't understand. And I've invited those champions of constitutional reform to share a platform with me so that I can examine, and we can examine together and publicly what are the changes that they are proposing. We come from a British legal system. We have laws that we have inherited that are hundreds of years old. We have a traditional legal system that's 100 and something years old. Our entire superstructure of this country is built along that legal system. We have changed a lot within that already. How much more can we change and remain in this legal construct in which our country is built? We may have to, if we want to create a different legal system altogether, then we may have to repeal all our laws and then start a new system, a new legal system altogether. So we have to be very cautious and circumspect in what we are attempting to change. And we cannot use and cannot allow constitutional reform processes to be manipulated by politicians who want to achieve an electoral end through constitutional reform. Electoral end can only be done through an elections. You can't use constitutional reform to get electorally elected. You have to go and win the elections. You can try to make the system, and that's what we are doing with electoral reform. And if it is that people feel that GECOM in its current construct is not suitable to discharge the functions of an elections commission, then we can also look at that, because that is a question for the Constitution again. If we believe that the process of appointment of the GECOM chairman and the various commissioners ought to be reviewed, then we can review it. That is a question for constitutional reform. But outside of this given structure, I don't know how. I see people are asking for put power sharing in the government, in the Constitution, so that all the people of Guyana, when the government lock hands together and all the politicians are on one side, who will represent the people of Guyana?
Well, power sharing, I personally don't agree with power sharing for several. I've written about that, but let's go on. Kublal wants to ask you a question. AG.
I just want you to comment on the proposed recommendations for ROPA.
Okay.
I know you talked about constitution. That's part of it.
No, yeah. So in the electoral reforms that we are doing, it is statutory reforms, not constitutional. Because, as I said, this is a government initiative which we promised after we saw and the world saw what went on in those 5 months where Mingo refused to use the statements of poll and wanted to declare results that he fabricated on a spreadsheet. When Lowenfield refused to use the statements of poll to tabulate and use the recount results to tabulate, but wants to tabulate his own results. And he wants to become judge, jury, and executioner and discount from counting 160,000 votes so that he can declare the PNC and the AFC APNU the winner of the elections. We can't go to another elections and have those possible loopholes not corrected. As I said, the same Lowenfield, the same Keith Lowenfield conducted the 2015 elections and did so admirably. He knew which results to declare then. He knew that statements of poll had to have been used as the basis for declarations. Mingo was the returning officer in Region 5 for the 2015 elections. He knew how to declare results in 2015. Come 2020, they don't know. You think they don't know? So you have our laws is as good as every other law in the Caribbean, election laws. What we had is a band of miscreants who ran amok and decided that they will pervert the system. But so we have to put checks and balances that will reduce discretions. So, for example, ROPA. We have a series. I mean, it's so much for me to talk about, but let me talk about the main ones. So, polling stations. We saw Lowenfield exercise his power and discretion in withholding adequate number of polling stations in PPP strongholds. Days or nights before the elections, we didn't know where certain polling stations were going to be. And it only happened in PPP areas, PPP stronghold areas. So we're putting in the law that all polling stations across the country must be declared and known X number of weeks before elections. All elections training manuals, etc., must be made public and must be known X months before elections. Nothing happening overnight. Because what we find is that when the wickedness starts on election day and you try to question it, somebody puts up a manual and says, we get this from the chief elections officer. We will all be singing from the same hymn book, and those manuals got to be in sync with the law. In terms of tabulation, before I get there, statements of poll got to be uploaded by the returning officer as early as possible. I think we stipulate a time. So, 100 years ago, we used to nail it on the wall of the polling station. And that was a publication of the results. Because that was what technology permitted then. You now have internet. Just interposing technological advances, and instead of posting it, in addition to posting it on the door, we're putting it up online. So the whole world will see the elections within a few hours. And every party got to do that. Every polling returning agents, returning officers are going to do that right across the region. And we also have mechanisms in place to allow GECOM to receive election results, not only the chief elections officer, as the statements of poll are coming in. So you have various checks and balances. Tabulation, for example. We are not going to have Region 4, for example, tabulating in one place. Each of these big regions, and they made an objection. They said we are targeting Region 4. We said, okay, we will do it in Region 3 and Region 6. Where these big regions, the populous regions, are already divided into electoral divisions. So Region 4, for example, has East Coast, East Bank, Georgetown, North Georgetown, I think, and South Georgetown. Those divisions will tabulate their results just like that. Region 3, for example, Essequibo Islands, West Demerara, West Coast Demerara, West Bank Demerara. We tabulate in those 3 election divisions. Same thing for Region 6. So you dilute the tension. I see people objecting that that can be fraudulent. How can that be fraudulent? We are disengaging the fraud or the attempts or the possibility of fraud. Instead of counting 500 ballots at one place, you're counting the 500 ballot, 100 each at 5 different locations. It's the same thing. Nothing is changing. We're not altering no boundaries or anything like that. And then we have a whole series. We have a whole series of provisions that deal with what the chief election officer must declare as the election results. And we strengthen the oversight that the commission must have over him or over that office, an office holder. We also dealt with registration and strengthened the system of cyclical registration, how this cyclical continuous registration. We also put in the law a mechanism that allows for the registrar of births and deaths to, at periodic intervals, send over all the dead people so the list can be constantly clean. We also put in it a mechanism that allows a list to be ready at any 6 months period. At every 6 months of the year, a PLE, a preliminary list of electors, would be ready and available in the machinery at GECOM. So that if there is any president who wishes to call a split election, you don't have to do like what Granger pretended to do. Get Patterson to say that he's not ready and then squatted in government for an extra 2 years. That will never happen in this country again. Also, we are protecting against the scrapping of any database because we have a court ruling from the Chief Justice of this country that says that if you scrap that database, you are disenfranchising every single elector already registered. And we are putting mechanism in place to have it cleansed on a daily basis. And I mean, I haven't read the provisions in a while, the changes, because I completed the task. And now, of course, we have done it with public consultations. So those changes should be taken to Parliament in the near future, and they will constitute together a massive overhaul of the electoral process. And let me emphasize, as I have done on every occasion that I've been asked to speak on this matter, every single reform that we are advancing is party neutral and not intended directly or indirectly to create any electoral advantage for any political party. They are all intended to strengthen the electoral machinery, to curb and regulate discretion where discretion existed, to block holes that are in the system and in the law, and to protect the rights of observers, for example. No president ever must be able to say, observers can't come. That is not a presidential power. That's a GECOM power. Those things are what we are going to clarify. Because recall, President Granger just blocked, for the purpose of the recount, blocked Carter Center and all the others from coming, and he said that CARICOM, in his own words, was the most legitimate interlocutor to oversee those that recount. And when the CARICOM people presented the report, and they said that he lost, and all his allegations were fairy tales and nonsensical, he then started to denounce those people.
Yeah, do you envisage that this action in Parliament will take place before local government elections 2020 or after?
I would like to think that it will be in the law for the local government elections. I think that is the expectation and hope of the government.
Okay, thank you, Bish.
Anything else you would like to share with us on electoral reform? Because we just have about 3-4 minutes remaining.
Oh, we all the time finished already?
Yeah, man.
Shamisa, you should ask for another hour. Anyhow, so the reforms are wide-ranging and they are intended to modernize the structure. But you all know, you all are educated people, and we all know, human experience would have taught us that you can have the most perfect system. But if you have bandits, and if you have dishonesty and dishonest people and miscreants manning that system, then perversity is inevitable. So we have to also assiduously work to ensure that GECOM employ objective and transparent practices and procedures in hiring people. Because the caliber of people that they hire will have a direct impact on the quality of elections we will have. That is the story, or the rush. That is the story that came out of the 2020 elections, and we must learn from our mistakes. So we are going to partner with international agencies, as we have done in the past, UNDP, Commonwealth, the United Nations, and organizations of similar ilk, to ensure that the system and processes within GECOM is thoroughly examined and strengthened and made transparent. We have to ensure that the staff of GECOM reflect the electorate. That is important. Because whether we want to admit it or not, ethnicity is a factor in Guyana's electoral politics. And the staff of GECOM, therefore, must mirror the population makeup as far as possible.
Yeah, on the question of, before we go, on the question of the composition of the GECOM commission, are you planning any changes in the structure of that organization?
Not in this electoral reform process, because the composition of the commission is a matter for the Constitution. When the constitutional reform process begins, it is up to the people of Guyana, because they are going to drive this process. It depends upon the recommendations we get. That is what will determine whether it is reformed and how it is reformed. Recall, government is not going to dominate this constitutional reform process. I want to make this plain. I have already put the government's proposal, and it is in our manifesto. It's 50% government and parliamentary opposition on the one hand, and 50% civil society organizations on the other hand, with a chairman who is to be appointed by His Excellency the President. Then the commission, once constituted, will have wide-ranging powers on how to regulate its process and procedures. It will also have the power to enlist experts as it sees fit to advise it on the way forward. The modus operandi and the work program, etc., of the commission will be determined by the commission itself. So this is not a process where the government has a hidden hand and is directing the show. That is how we in the PPP do things. And that is what APNU could not have done, although they promised. Well, they didn't want reform. Anyhow, they wanted to rig. to stay in power.
Thank you.
Before you go, could you give us an update on the present election petitions?
Okay, so one election petition was dismissed, petition 99, and they appealed to the Court of Appeal. We have said to the Court of Appeal that you don't have jurisdiction to hear this appeal in accordance with the laws of election petition. Our constitution, which has the relevant provisions applicable to election petition, says that an appeal lies only when there is a determination of the question raised in the petition. The question raised in the petition was never determined because they never served the petition in accordance with the rules, and the petition was dismissed prematurely. So there is nothing to appeal. There was no determination. And that we contend is the policy of election law. There must be a determination of the petition because the business of government must go on. If you are not fit and proper to even get service of the petition right, you are not qualified to hold up a whole government. It's as simple as that. That is the rationale. So the Court of Appeal disagreed with us, and we have appealed their decision, a majority decision of the Court of Appeal, the same two that says 33 is not a majority of 65. They have ruled against us, and we are going to the Caribbean Court of Justice. That appeal will be heard on the 19th of July. The other appeal, the other petition that where they challenge Order 60. Remember, they sat and they drafted Order 60 with the chairperson, Alexander Corbin and Trotman. And GECOM produced Order 60 by which they did the recount. When they lost the recount, they have a problem with Order 60. The same thing that they did, they agree with the PPP in 96 to pass a law that says you must use ID card as a voter qualification. When they lost the election, they go to the parliament to challenge the election on the very basis of that law. The same thing, they crafted Order 60, they go do the recount. When they lost their recount, they put their own watchman. They select their own watchman to oversee the recount. When the recount was done against them, and the very person that they put to overlook the recount says that they were speaking foolishness and their allegations and objections were puerile, they vex. So they challenged Order 60 in this petition. That petition was dismissed, and we had argued. They appealed again. We heard the arguments in the Court of Appeal, and the Court of Appeal is to rule. I think that's where that one is.
Okay, and your closing remarks before we leave?
It's 2 minutes.
Try to.
Well, I hope that I have given a perspective, and I've done so adequately in relation to constitutional reform generally in Guyana and constitutional reform as presently being contemplated by our government as promised in our manifesto. And I also hope that I've shed some light on the proposed electoral reforms that we are pursuing, which we will soon lay in the parliament. I want to thank you very much for affording me this opportunity to speak to you and your audience and viewers. Thank you.
Shamiza.
We appreciate it, Attorney Nandlall. This evening we heard from you. We heard you're energetic, you're passionate, you're very knowledgeable. And for me, that is important, right? Elections historically in Guyana has shown a divide in our country. So having this discussion today is key. And I hope we can do another session where you can come back, hopefully very soon, and we can have a follow-up discussion on this. And I will be happy to have my panel here again to join us. Now, it from what I heard tonight, it just seems like, everything that is needed for an election is there. It's present. I heard fairness, transparency, accountability, which are all key factors in having a good election. And I heard all of that tonight. So I want to thank you for being here. I want to thank my panel here. And until next time, good evening to you. Good evening to all our viewers. Take care.
Thank you very much, AG.
Thank you very much, AG.
Thank you. Thank you very much. It was a pleasure.
You're off here.